When you look at the future of regulatory takings, you have to look at the past first. And you recall the first modern regulatory taking case came in 1922. And then we had to wait until the 1980s until we had some more significant regulatory taking cases where landowners actually began to win. Since that time, every few years, there's been another regulatory taking case, really helped out in one area or the other. But only in the past year, we had count them, two decisions in the very past year, last summer, that came down. And today we're going to talk about these cases, what happened in these cases, how we got to where they are. And then we're going to do a little bit of speculation based on the past of where we think we're going to go in the future and what kind of future do we see for regulatory takings and property rights, especially at the Supreme Court. We have two cases that we'll be talking about, the Cedar Point case and Pactel. And to talk about these cases, we have two very able and distinguished lawyers who will talk about them with us. One is Joshua Thompson. He's a senior attorney in Direct C Legal Operations at Pacific Legal Foundation. Joshua joined PLF in 2007. His litigation practice has had particular focus on equality of opportunity, and he argued our 13th case before the United States Supreme Court, Cedar Point Nursery versus Hasid, which we'll discuss shortly. Other litigation highlights of his include ending a decades-long racial quota in Hartford, Connecticut, lifting a ban on boys dancing in Minnesota, and vindicating an entrepreneur's right to start a moving business in Kentucky. Joshua's writings have been published in the USA Today, Wall Street Journal, the Washington Post, and numerous law review articles and numerous law reviews. He has appeared on national television and radio, including the PBS NewsHour, NPR's All Things Considered, Stossel, and Univision. Joshua earned his BA with distinction from the University of Wisconsin-Madison with a major in poli-sci, international relations, and German, which he will be not talking with in today. He earned his JD cum laude from Michigan State College of Law and is on the Law Review and Trial Practice Institute. Joshua lives in Sacramento, California with his wife and 3 children. He loves playing chess and rooting for the Wisconsin sports teams. They have a team still? Paul Utrecht. Paul Utrecht is our second guest. He has been representing clients in dispute since 1985 and has emphasized real estate litigation since 1993. His practice includes resolving disputes in most substantive areas of real estate law. He has represented a broad spectrum of property owners, from the owner of a single-family home to institutional owners with many properties, both commercial and residential. He has represented clients before local administrative agencies, as well as those with cases in both state and federal trial courts and appellate matters requiring representation in the California appellate courts and the California and United States Supreme Court, such as the case San Remo Hotel versus City of San Francisco that he argued back in 2004, and decision came down in 2005, if I recall correctly. I should mention that my name is James Burling. I am the Vice President for Legal Affairs of the Pacific Legal Foundation. I've been litigating environmental and property right cases since I began 38 years and 1 day ago at Pacific Legal Foundation. And enough about me. Let's turn it over to Joshua. And Joshua will talk about the basic facts that led to the Cedar Point case. Joshua?
Thank you, Jim, and thank you for that very kind introduction. Thanks to everybody for joining us today for this interesting webinar. It's interesting how Cedar Point came about. I didn't remember myself, but as we're sort of going through emails to do our due diligence after the case and collect the attorney's fees that were due, it sort of gave me some reflection on how it came about. And it actually came about, Jim, by you sending me an email one random September morning that said, hey, are you aware of this agricultural access law? I know you were looking into something similar. Is this something you want to look at? And 6 years later, we get a Supreme Court decision affirming the right to exclude. But that email sparked a conversation with attorneys here and elsewhere in California about the Agricultural Labor Relations Act access rule. Now, this regulation existed, was promulgated in 1975, a day after the newly enacted Agricultural Labor Relations Act was adopted by the legislature. It was initially an emergency regulation that allowed agricultural unions access to private businesses for the purpose of soliciting their employees to join unions. The regulation was immediately challenged in court and was actually enjoined by the Superior Court, or a couple Superior Courts in California, before eventually being upheld by the California Supreme Court in 1976 against a takings challenge, a similar challenge that we ended up bringing 45 years later. So the access rule was in place in California from 1975 until just this past a couple months ago. And what it allowed is it allowed unions to provide notice to the Agricultural Labor Relations Board that they were going to take access, which essentially means invade private property, for the purpose of soliciting the workers. We were initially contacted by a couple businesses that this happened to in the summer of 2015. For various reasons, those inquiries didn't pan out. But while I was researching this issue, the event at Cedar Point Nursery occurred. Now, what happened at Cedar Point Nursery? Cedar Point Nursery is a small strawberry nursery in Northern California. One thing that I learned litigating this case is that the nation's strawberry plants are almost all exclusively grown in this very small region of Northern California. That's not where the strawberries are grown. The strawberries the plants are shipped to Southern California, shipped to Mexico, shipped to Florida, but the plants themselves are grown in this little mountainous region in Northern California near the Klamath Falls. And this is a very remote part of California. The town where this nursery is located has 600 people. Really have never seen the agricultural unions in that part of the state. They have a very short harvest season. They have a 6 weeks window where they have to harvest all these plants. So for 4 weeks out of the year, they will hire a number of migrant workers to help harvest their plants and get them shipped to the various producers of strawberries. One cold October morning at 5 a.m, these workers were in the sheds cutting the plants when the UFW stormed onto their property with bullhorns in hand. We have video on our website if you want to actually see this event, how it happened, and scared the living whatever out of the workers and the business owner. They didn't know about this access rule, had no experience with it, didn't know it existed. So they called the police. They said, the UFW is on our property, come here and get them off. The police came and said, actually, if you try to kick them off, we're going to have to arrest you. They have a perfect right to be here under the access regulation. So that led Mike Fonner, the owner of Cedar Point Nursery, to contact us. We eventually filed suit months later, challenging the access regulation as a violation of the Fifth Amendment, because our argument was from the outset that it took an easement-like interest from the property owner without compensation. The case was dismissed shortly after being filed by the district court. The Ninth Circuit affirmed that in a split opinion. The full Ninth Circuit denied en banc hearing, but there were 8 judges on the Ninth Circuit that dissented, which led to our cert petition, where we asked the court to hold whether the uncompensated appropriation of an easement that is limited in time affects a per se taking under the Fifth Amendment. And that is the issue that the Supreme Court granted cert on. And I suppose I'll leave it there before we talk about what the Supreme Court held and how the argument went or how the briefing went. But that's the background of the case. And back to you, Jim.
All right, because we're going to get back to what the court actually did, but we want to set up Impactdale first. But Joshua, let me just ask you a couple of questions to clear the air. First of all, is this case about unions in a way to limit their power? Is that why PLF got involved in this case?
No, PLF has no, we have a scant history with unions where it's not a part of our strategic plan to be involved in union issues. We have a long storied history of advocating for property rights. at courts throughout the United States, and especially the Supreme Court. I think Cedar Point is PLF's, I don't know what Jim probably knows better, 5th or 6th Supreme Court victory on property rights exclusively. From Nolan to Jim's Supreme Court case, Palazzolo.
If you count the wetland ones, it's about the 10th or 12th.
Yeah. We are certainly known and are interested, and our donors support us for our property rights advocacy. And there are other organizations that are very interested in union issues: National Right to Work Foundation, Freedom Foundation, Liberty Justice Center. Those aren't our issues. Our issues are property rights.
Property rights and free speech and discrimination and things of that nature. Joshua, one more question before we move on to Paul. In 1977, the California Supreme Court held that the union access rules did not take the property of farmers. So what had changed to make you think you could have a different result 40 years later?
Well, that was an interesting opinion. It's a 4-3 opinion, and at the California Supreme Court. And I think even the state of California didn't try to defend the rationale of the California Supreme Court. Takings law had certainly changed since 1976. We didn't even have the sort of the per se takings rules at that time. Loretto's doesn't happen until 5-6 years after that. So we were pretty confident that the reasoning of that case couldn't stand. Now, there were other hurdles, the Williamson County hurdle that I think we'll talk about in a little bit. And California did defend on the grounds that this was res judicata. This case had already been decided. But the rationale of the California Supreme Court, we don't think could have held up in federal court given current case law. And so we were willing to take the case and try to establish that important federal precedent.
Thanks, Joshua.
I have a question for Joshua before we turn to me.
Sure,
why
Paul.
didn't you bring the case in California courts?
Because there, I do think it would have been res judicata. The California court had decided this precise issue. Maybe not. I don't think our clients were necessarily bound by that, but the law had been definitively decided that this regulation under California's interpretation of the federal takings clause did not take a property interest. Now, I suppose we could have argued that there had been a change in law and changed circumstances, but we didn't feel very confident that the California courts would provide us relief. This case was always designed with a long shot hope of getting to the Supreme Court. Now, that's not to say we didn't argue that we should have won at the district court or at the Ninth Circuit. We certainly thought our arguments were good enough to win at every level. But we are an appellate outfit that tries to establish important appellate precedent. And this case was designed to do that, and it eventually did do that. But we thought the best chance of establishing that precedent was in the federal courts and not in the state court system.
So, Paul, let me turn to you. And a quick remark, of course, is the California state courts are a graveyard for property rights. So let's move on to Pactel. Paul, what was the Pactel case all about?
So Pactel had a similar experience. We were not interested in going to the California state courts for Jim's reason that they're a graveyard for property rights. So what happened in Pactel was Mr. Pactel and his wife were looking for a retirement home. And they wanted to retire to San Francisco. They actually live in the Midwest, but they want, when they retire, to live in our beautiful city. And so they looked around for a home and they found a home. And now the home they found is an unusual, it's very common in San Francisco, but it's unusual nationwide. It's called tenancy in common. Essentially what they did was they purchased a part interest in a 6-unit building, and coming with that 1/6 interest in the building, they got the right to occupy one of the 6 apartments in the building. San Francisco has always, well, since the 1980s, has had strict limitations on the ability of owners to convert from tenancy in common to condominiums of old buildings, or pre-1979 buildings for sure. And as a result, buildings that might be condominiums in other cities are held as tenants in common. It creates a whole bunch of problems. but by contract, you create many rights similar to those of a condominium. The biggest distinction is you cannot through conventional financing, finance a tenancy in common ownership interest as you can a condominium. So they found this property. It's a beautiful property. It's on Nob Hill. They have one of 6 units. Because they were planning to retire, they decided to rent out their unit. They entered into a contract with the other owners, and they said that when the city allows them to convert to condominiums, they would all comply, they would all participate and convert the building to condominiums. San Francisco at that time had a lottery, and some people won in the first year, but I think on average it took 6 to 7 years to win the lottery and get the right to convert the building. Before this building won the lottery, the city changed the rules, and the new rules said that if you converted a building to condominiums and one or more of the units had a tenant in place, the tenant had to be given a lifetime lease. Now, here in San Francisco, we have rent control, puts strict limits on the ability of landlords to raise rent, also puts strict limits on the ability of landlords to evict tenants. And many landlords feel like that's the equivalent of a lifetime lease, but it isn't, because there are many remaining options to terminate tenancies. So city created this requirement. The Pactel owners of the building all decided to convert to condominiums, and they did so, and the city required Mr. Pactel and his wife to grant a lifetime lease to their tenant. We sued in federal court to undo that or obtain money damages as a taking. And basically that's the factual setting is they are now precluded from retiring to this property because it's going to be occupied by a tenant who's younger than them for the remainder of his life and potentially for the life of certain specified relatives of his. So they basically are never going to be able to get into their retirement home.
So Joshua had already gone through a little bit of the litigation history of Cedar Point up to the point of the time we were at the Supreme Court. So before we turn back to him and what happened at the Supreme Court, Paul Utrecht, could you give me just a little bit of the litigation history? You mentioned before you didn't want to file in state court for good reasons, but what happened? The Ninth Circuit told you that you couldn't pursue your claims until you exhausted these administrative remedies. What does that mean?
So what happened in Pactel was when we filed in the district court, the rule was under Williamson County that you had to go
and Paul, just a quick what is Williamson County?
Under Williamson County, the Supreme Court held in 1985 that before a federal takings claim was right to be brought in federal court, it first had to be brought in the state courts. And then in the San Remo case that I was involved in, the federal court said when you lose your takings claim, your state takings claim in state court, when you return to federal court, the state decision will be res judicata and you will lose your federal takings claim. So you will never get a federal court to decide your takings claim.
And res judicata essentially means the case has already been decided and we're not going to hear it anymore.
Correct. The federal court said that the state takings claim was basically the same as the federal takings claim. And therefore, having lost, you get one bite at the apple, not two. And so you had your one chance and that's all you get. We filed, even though we thought that was wrong, we decided to file in the federal district court in the hope that that rule would get changed. But it didn't get changed when we were in the district court. So the district judge said, sorry, you got to go to state court first. You can't come here. So we appealed to the Ninth Circuit. While that appeal was pending, Pacific Legal Foundation won the Nick case. And in the Nick case, the Supreme Court basically reversed Williamson County and said, no, federal takings claims have the same ability to be brought in the federal courts under Section 1983 as any other First Amendment, Second Amendment, Fourth Amendment claim. And
Section 1983 is part of the Civil Rights Act, which allows anybody to go into any court to vindicate their civil rights if they've been violated by any government.
Right. And so the Supreme Court said, yes, you can go to federal court. So now we're in the Ninth Circuit, and we say to the Ninth Circuit, sure, at the time the district court decided the case, Williamson County was the law. So we get why the district court made that decision. You, Ninth Circuit, should reverse him and tell him to follow the Nick case. So we were reasonably confident that we would win in the Ninth Circuit. But when we got to the Ninth Circuit said, well, wait a second. There's two separate holdings in Williamson County. The first holding is that you have to have exhausted your administrative proceedings and obtained a final decision from the government as to what your allowable use is. And the second holding was that you had to go to state court first. Only the second holding was reversed. Only the second holding of Williamson County was reversed in the Nick case. So the first requirement of a final administrative decision had to be met. So the city said, well, aha, they could have done some administrative variance procedure along the way, and they didn't do that. They asked for relief from the city, but they didn't follow one or more steps that were available. And we said, wait a second. What Williamson County held was you needed a final decision, not that you needed to have exhausted every step along the way, because there was also a case, Patsy, from the US Supreme Court that held that Section 1983 plaintiffs are not required to exhaust administrative remedies. So the question before the Ninth Circuit was, did we have a final decision? The city acknowledged that we had a final decision because we couldn't go back and ask for those variances because all those deadlines had run. And so the Ninth Circuit said, because we could have done that in the past, we didn't satisfy the finality requirement of the first holding of Williamson County. So that's where we sat in the Ninth Circuit. We petitioned for rehearing, and we got eight judges on the Ninth Circuit to agree with us, but we needed 13, I think. So then we went to the Supreme Court, and that'll come next after Joshua explains what happened in Cedar Point.
Yeah, so now we're on the brink of being at the Supreme Court. Supreme Court is ready to give the decision. So Joshua, what happened at the Supreme Court level in our case, the Cedar Point case?
Sure. As I mentioned earlier, the issue that we got the court to grant certiorari on was whether the uncompensated appropriation of an easement that is limited in time affects a per se taking under the Fifth Amendment. So it's a pretty short QP, all things considered, but let me unpack what each of those things mean. We had argued from the outset, if you look at our complaint, we had characterized what the access regulation was as an easement. And we thought we did so strategically because we felt that given Supreme Court precedent, if you can get something clarified as an easement, then it's a foregone conclusion that the government can't take that without compensation. Throughout the litigation, for most of the litigations, the state of California never denied that it was an easement. It said, it doesn't matter if it's an easement. The fact that it's not 24/7, 365 means that we can take an easement without having to compensate you. And so that was the issue that we got cert granted, whether an easement that is not through 24/7, 365 requires compensation before it is taken by the government. Once we got to the Supreme Court, the state of California changed its mind. It said, no, this isn't an easement. If it were an easement, of course we'd have to pay, but because it's not an easement, we don't have to pay. And we know it's not an easement because it's not recorded on your property. You can't transfer it. It's not alienable. This is just a business regulation. So they're right about those things too, right? This isn't on all fours with an easement. There are differences between a traditional easement and what this is. We thought that given Supreme Court precedent, there were cases going back to the 1920s of guns being shot over property, where the court called that an easement, even though that also wasn't transferable or alienable. So we thought the sort of everyday understanding of easement was sufficient, but when the state of California started pushing back on that, we said, well, what does it really mean? What we're really talking about here is the right to exclude. And the state of California has taken away the right to exclude here. Whether you want to call it an easement or a servitude, or whether you just want to say the right to exclude is being denied, that's what matters. And compensation is owed whenever the government denies you the right to say who can and cannot be on your property. And so briefing sort of changed in that mode, and whether the right to exclude could be infringed in the manner that California was infringing it in our case. And less important became this easement language, which we thought was going to be the most important part initially. Do you want me to go, Jim, into the holding of the court, or?
Yeah, let's go into the holding of the case, and I'll give Paul a chance to talk about the holding of his case, and then we'll have some questions and open it up to questions at that point. So, what did the Supreme Court hold?
So it's a good question, and I've been asked that a lot, and I don't think it's obvious. And I've asked the members of my team and people here how they would clarify the Supreme Court's holding, and I've gotten three answers that I will give you, and I'll end with my favorite one. So first is, it's unconstitutional for the government to give third parties the right to access your private property. The second would be, the government takes your property when it allows others to use it as their own. But I think it's much more simple than that. I think the ruling, the holding of the Supreme Court is simply that the denial of the right to exclude requires compensation. And if the government doesn't compensate you, it's an unconstitutional taking. Now, there is a little bit baked into when I say denial of the right to exclude. There's certain exceptions that I don't think rise to denying the right to exclude. We'll talk about those exceptions. But when you possess the right to exclude somebody or something, and the government takes that away from you, be it for 1 minute, 1 day, or in this case, 120 days, 3 hours a day, the government has to compensate you. And the extent of that denial, the extent of the denial of the right to exclude may go towards how much you're owed, but it doesn't go towards whether there is a taking in the first instance.
So bottom line, we won the case. We know that when government intrudes on property, there are limits to that. And those limits are more clear, but there are still a lot of ambiguities out there that we still have further cases to help clarify that some more, because the Supreme Court never gives us great black and white answers that you can apply in all cases. So Paul, let me turn to you. You had filed, in your case, attorneys, we and you had filed a petition for writ asking the court to take up the case. And we had hoped that the court would take the case, set out time for oral argument. People would go back to Washington, D.C., or go on Zoom, whatever the court was going to do at that time, argue the case, and then come up with a decision sometime in June of 2022. So what actually happened?
So we asked the Supreme Court two questions. The first question was essentially saying that the Ninth Circuit had not followed the Supreme Court's decision in Nick. They had effectively misread it, and that the Supreme Court should grant certiorari and issue an opinion basically explaining what it had held in the Nick case and making it clear to the Ninth Circuit and other courts that didn't want to follow it, that they meant exactly what they said. So that was question one. Question two was, the Ninth Circuit had rejected our takings claim on one of our takings theories. They rejected on the ground that the imposition of this lifetime tenancy requirement was done by legislation rather than by administrative decision. And there are cases that PLF 1, Nolan and Dolan from the 1980s that said that when the city imposes a condition that takes property from you, that condition has to be measured by whether it is justified by the extent of the development that the owner is trying to put the property to. So there has to be some rational nexus between the owner's new development and the condition the city's imposing on you. And the Ninth Circuit said none of that matters, because when it's done by legislation, there's no such requirement of proportionality, and the city can, by legislation, do whatever it wants. So
and
that was
the
our
city was
question.
not basing its argument on anything in the Nolan or Dolan or Kuntz decisions, correct?
The city's argument, which was adopted by the Ninth Circuit, which has been standard law in the Ninth Circuit for a long time, is as long as the condition is imposed by legislation, none of those things matter. It doesn't get subjected to the questions of Nolan, Dolan, and Kuntz. Those are just completely irrelevant cases when the condition is imposed legislatively. So that was our second question. The first question that we asked was obviously an easier question than the second question, because we're basically asking the Supreme Court to say, you know, we meant what we said. And so we were set for a conference in early June. And
a conference meeting when the Supreme Court gets together and decides whether or not to take a case.
Right. the Supreme Court gets together on Fridays and goes through a list of cases, and 99% of them get rejected, and 1% of them get set for argument the following year, usually. And when ours came up, instead of granting certiorari and setting it for argument, the Supreme Court said, well, we can take care of this question number one, no briefing, no argument. We can just issue an opinion. So they issued an opinion that basically said the Ninth Circuit was wrong and that it should have followed the court's decision in the Nick case. So not very interesting, but one of the things that they said was that on remand, the Ninth Circuit should reconsider the merits of our takings claims based on the Cedar Point decision, because our case does not involve 3 hours a day for 120 days a year of exclusion of the owner. Our case involves the lifetime of the tenant. The owner is excluded from the property. So I think the hint to the Ninth Circuit was, these ideas of yours about takings law might be worth reconsidering because we are taking the right to exclude very seriously. So they told the Ninth Circuit to reconsider that question. And the Ninth Circuit decided to punt, and it told the district court to reconsider that question.
And so we're now back at the court, back to the district court, trying to decide whether or not the cases of Nolan and Dolan, which set limits on the kind of exactions or impositions can be put on property development, whether that applies here with the lifetime lease. So there's more interesting litigation ahead. We're starting to get some questions in, and I'd like to turn to some of the questions, and I have a whole bunch of my own too, that when we run out of questions from the audience that we'll move on. But let's talk about some of the implications. Now, Cedar Point and Pactel shows a symbiosis between some of these cases. You have, or even Nolan and Dolan before that, all these cases build upon one another. We set up one set of precedents in the 1980s, and that affects what we do in the 2000s, and now it affects what we do in the 2020s, and the Cedar Point case is affecting the Pactel case. But let's turn to some different situations. We had a question about how this might apply to some of the rules in Florida, saying that people are allowed to drive on beachfront land. And some owners are saying this is our beachfront land and the public doesn't have a right to drive on it. Cities have said, no, of course they do. So I wonder if any of you, maybe you, Joshua, would like to answer the question of how this could apply to driving on beachfront property, on privately owned property in Florida.
I think that is probably one of the most straightforward and easiest applications of Cedar Point Nursery. If you have private property on the beach and the government comes in and says, we want to build a road across your beachfront property to allow the public access to the beach, well, that is not only I don't see how that's not an easement on all fours. And notwithstanding the government's maybe profound interest in allowing access to beaches, whether you buy that or you don't buy that, the government, if it wants to take that access or wants the public to have access to your beachfront property, it has to pay it. It has to pay it even probably prior to Cedar Point, but certainly after Cedar Point. Now, I don't know the peculiarities or the particularities of the Florida law. Maybe they were paid, maybe it was, I don't know. You could think of some other reason why compensation may not be owed, but if this is a private landowner that owns that property and the government comes in and says we need access to the coast for the public, that is prohibited under Cedar Point unless the government pays compensation.
Yeah, and I should mention that one of the complications is something called the public trust doctrine, which could be a subject for an entire different seminar. The idea that underlying your property rights, there are easements that the public owns to access to and along the coastal areas for purposes of navigation. That's been expanded dramatically in some states like California to include recreational uses of the coast. But whether or not that applies in a particular situation in Florida remains to be seen. I know there's a lot of active litigation about that. We've been involved in some, and we will see. But typically, if the government is demanding to have hikers go across your property or wants a piece of it or wants to allow people to go onto your property for various public purposes, such as visiting grave sites in the Nick case, that's a clear violation. And I think Cedar Point makes that much more clear. Now, government talked about some, but the court talked about some exceptions for inspection regimes. So, those are sort of the balancing cases that we look at, and it could be we're devolved into more balancing, which does lead me to the next question about Penn Central and the future of Penn Central. For those who are not intimately familiar with Penn Central, that was a case where the Supreme Court said you have to look at certain factors and weigh them to determine whether or not there's a regulatory taking, whether or not a regulation actually affects the taking of property. You look at the economic impact of the regulation. You look at the owner's investment-backed expectations, which is kind of squirrely and amorphous. And you look at something called the character of the government regulation, and we don't exactly know what that means in all cases. Certainly a physical invasion by trespassers like we saw in Cedar Point is a sort of character that could lead to a taking. But of course, in physical invasion cases, it's a taking, and it shouldn't matter what the nature of the economic impact is or what your investment-backed expectations are. But let me turn to this particular question. What do we think of Penn Central and the future of Penn Central? Because even Sotomayor said, maybe it's time to update that. Paul, let me turn to you. What do you think the future of Penn Central is?
So the biggest problem with Penn Central, as far as I can tell, is it gives these 8 factors for the court to consider, and there are no real bright line tests in there. And so it gives huge amounts of discretion to the trier of fact, the trial judge usually, to say that, sure, four of the 8 factors favor, or even 6 of the 8 factors favor the property owner, but the other 2 are way more important and they favor the government, and therefore there's no taking. There's no guidance from the Supreme Court about how those factors get weighed and connected against each other. And so particularly in the California state courts where I'm operating, even the California federal courts where I'm operating, having a district judge with that amount of discretion deciding the Penn Central question makes it a really uphill battle for property owners. And it's not even so much that it's an uphill battle. We can all handle an uphill battle, but it's like we don't even know where the goalpost is that we need to reach to win. So I think Penn Central is a tough, really tough standard in California, for property owners.
So Joshua, let me turn to you. A question has come in about how this could affect the rate of compensation for coastal property owners in California, especially, but in other states as well. They're often being prevented from protecting their beachfront property, which creates essentially an invasion from Mother Nature, from the waves that they would otherwise be able to protect their property from. So in addition to the Coastal Commission demanding that people give up access across their property that we beat them in the 1987 Nolan case, we have this question of the inability to protect property from the forces of nature. Are there takings implications there, Joshua?
I think there are takings implications. I don't know that it is governed entirely by Cedar Point Nursery. And in Cedar Point, the government is authorizing third parties. It's denying you the right to exclude. And I don't think, I don't know, maybe Jim, you have a different view, but I don't think what is contemplated by that decision is forces of nature, or even you could imagine critters where you can't like fence off wolves or something like that, is necessarily contemplated by Cedar Point Nursery. But Jim, maybe you have some other thoughts about it.
Yeah, we do have cases from the California court saying that your inability to keep out Thule elk, those big beasts that chomp all the grass out of somebody's alfalfa field, is not a taking because the elk are not an instrumentality of the state of California. And so the idea that an act of nature can somehow be a physical invasion is a bit of a reach, but there is a fundamental right to protect one's property. And if that right is being taken away, I think there are takings implications. The courts haven't reached that, but that could be something for future litigation to take a look at. People have made similar arguments in other states, such as Massachusetts, a number of decades ago. Didn't go very far, but things have changed. And my feeling about property rights is just because you lose the first case, you shouldn't give up. Just like we lost, or the farmers lost in the 1970s with the first challenge to the ag rule allowing union organizers onto property. They lost that, but we come back here 40 years later, we win. So the law can change. Paul, getting some questions coming in about rent control, one of your and my favorite topics. California and San Francisco has its bit of rent control for a long time. In New York State, somebody writing from the formerly great state of New York has had its rent control, which is extremely draconian. I want you to comment, Paul, on the future of rent control, but I would first recommend that people look at a column that I just had published this morning in The Hill on New York's rent control case and the Second Circuit's challenge to that, which could be quite profound. Perhaps we'll get a link to the Hill article coming up on our feed shortly. But if not, do a search for the Hill in rent control and you see that article. So Paul, what do you think these cases bode for the future of rent control?
So until 2005, so back in the 1990s, we were optimistic that there was the possibility of getting the courts to find that rent control was an unconstitutional taking. PLF was instrumental in some of those cases, the Santa Monica Beach case that went to the California Supreme Court. We were very hopeful that the Lingle case, Lingle v. Chevron, which the US Supreme Court decided in 2005, would be good for us. That case involved rent control for gas stations. So it seemed like an easier case for the Supreme Court than rent control for housing. So we were, until 2005, pretty optimistic about the possibility of getting rent control to be unconstitutional. And then the Supreme Court basically came in the Lingle case, and it was not technically a takings case, it was a substantive due process case. But the rationale of the court and the attitude of the court at the time was extremely in favor of rent control. I was actually at the argument in Lingle, and Ruth Bader Ginsburg asked a question, the details of which are completely irrelevant, but the spirit behind it was, what will all my friends in New York do who built their lives around their cheap rent controlled apartments do if we find that gas station rent control is unconstitutional? Because the next step will be residential rent control is unconstitutional. So I've been advising local groups in San Francisco that the chance of finding rent control to be unconstitutional was, verging on nil. But both the Cedar Point case, the Alabama Association of Realtors case, which found the holding in that case was essentially that the CDC's eviction moratorium was not allowed by the CDC's statutory authority. So it's technically not a takings case. But along the way, one of the things that the Supreme Court said in that case was that the eviction moratorium interfered with the owner's right to exclude, i.e. the owner's right to evict their tenants in that particular case for not paying rent. Historically, many courts have said, wait a second, we're not interfering with your right to exclude tenants. You voluntarily invited those people in and you chose to give them possession of your property. And all we're doing is saying, like any other state law, there are circumstances in which you can terminate the tenancy and there are circumstances where you can't. And one of the circumstances where you can't is where you're trying to raise the rent on the tenants. So the combination of the Cedar Point holding that 3 hours per day of 120 days impinges on the owner's right to exclude, and the eviction, depriving the owner of the right to evict the tenants impinges on the right to exclude. And if we add in, if Pactel were to win and they found that lifetime tenancies were impinging on the owner's right to exclude in a way that rent control does not, the next step would then be to say that rent control impinges on the owner's right to exclude. Now, there's a case, Jim mentioned, the CHIP versus New York, which is a huge panoramic attack on rent control. I mean, they go back the complaint in that case goes back to the initial adoption of rent control in World War II and talks about all of its iterations and all of the various regulations that it imposed. So it's like this comprehensive attack on rent control. That would be grand if that won either in the Second Circuit or in the US Supreme Court.
Thank you, Paul. Joshua, just a quick question. How does the ruling in Cedar Point apply to other unions, if at all?
I don't think it does. I think, well, other unions or other areas of union activity, I guess. I think it applies to every union that wants to take access in California. They no longer can't. The National Labor Relations Act has a similar access provision. This is the subject of Kavanaugh's concurrence in Cedar Point Nursery. That is very, very nuanced in that it only allows access under very limited circumstances. In fact, I don't know that it's even used today. But presumably, if it is used, that could, the Cedar Point decision could speak to the continued legality of it, the access provision under the National Labor Relations Act. But as far as this being a union decision, it's not. It's simply a property rights one that prohibits anybody, unions or whomever, from accessing private property without compensation.
A couple quick questions. What do you do when a city allows a desired conditional use on one's property, then says the zoning is incorrect, but doesn't fix the zoning? So in other words, this sort of case that happens when the city simply doesn't want to allow something to occur, despite what the zoning might say, and it simply ignores its zoning, ignores its general plan, and simply denies the ability to develop a project. Which one would one of you like to take on that question?
I'll take that on. We find in the California courts, state courts, that there is effectively zero sympathy for that kind of claim. It's regularly done in San Francisco. It's really tough because one of the things that the administrative agencies typically claim is that they are simultaneously interpreting the zoning law as well as acting on the conditional use authorization. And then the California courts defer to that agency interpretation, even though the agency interpretation is exactly diametrically opposed to what the words of the ordinance are, and diametrically opposed to what the agency's done for 25 years, but the courts still defer to it. So those are really, in California at least, those are really tough cases.
So unfortunately, we only have time for one more question, which I will have the prerogative of asking on this one. Some of the others we'll try to get to if we, I don't think we'll have time for those, but I'll try to answer those when we type this a little bit later. But my question for both of you is, how does the current composition of the Supreme Court changed our reasonable expectations about property right cases? And what hope do we have for the future of the Supreme Court of these kind of cases? Let's start with you, Joshua.
Thank you, Jim. I don't like to think of the Supreme Court that way. I don't think that it ought to be thought of that way. It is not a partisan institution. It is an institution that is designed to uphold the law and interpret the Constitution. I think that our arguments ought to carry the day regardless of the appointee of the Supreme Court. And I don't change the cases that I'm going to bring or that I think are in violation of the Constitution based on who's sitting at the Supreme Court or who's sitting at the Ninth Circuit. I mean, it's so rare that you're going to get a case to the Supreme Court. I mean, we've had 16 in PLF's history, but we've also probably had 500 that have been denied by the Supreme Court. So to take a case to try to set appellate precedent that you will only succeed if it gets to the Supreme Court, I don't think is a wise litigation strategy by a public interest outfit like ourselves. I think that we take cases that we think can push the law forward, but that can be accepted by jurists of any political stripe. So I don't look to the Supreme Court's in that way, and so I'm probably not the right person to answer that question.
Paul.
So I learned constitutional law from Jesse Choper, and the first thing that Jesse Choper told us all was the first thing you do with any case is you analyze the doctrines of the existing case law and figure out who should win the case based on those doctrines. And then he said, the second thing you do is you count votes, because not everybody agrees equally as to every doctrine. And so you have to look at each individual Supreme Court justice's views on the point. And most of them have views over time. Even if they don't express them at the beginning, they have views that over time become apparent. And so, for example, Alito, Gorsuch, and Thomas have a historical track record of being very, very good for property rights. Roberts has been reasonably good for property rights. That's 4 votes. Kavanaugh in the Alabama Association of Realtors case looks like a good vote. Amy Coney Barrett looks like a good vote. And then, so you're up to, 5 or 6 justices that have pro-property rights leanings in their history. Now, does that mean that they're going to rule in favor of property rights every time? No. Does that mean that we have a receptive audience for these claims? I mean, I understand that you can't bring every case because it's going to the Supreme Court, but I know that Pacific Legal Foundation brought, 10 or 15 cases like Nick to the Supreme Court before it got granted. So you guys kept going, even on a point where we'd lost, you kept going saying someone has to do this. And so eventually you had to wait for a court that was more sympathetic. So does that mean that you're pursuing wrong cases under a different court? No, it means that you're making the best argument you can for your client, but you also have to make an assessment. This court is better for property rights than the court was 5 years ago.
Thank you. We have some more questions that have come in. We just don't have the time to answer them right now. I'll say that one thing that we at Pacific Legal Foundation like to do is, as you just mentioned, Paul, is not give up. Yes, you lose one case, that doesn't mean you can't bring another. Now, you can't bring the same case with the same parties, just try a different court, because you do have res judicata issues there. You can't relitigate the exact same case. But if we're trying to establish a principle at the Supreme Court or the Court of Appeals, we can find different parties that are injured in somewhat different ways or similar ways, but different parties, and we can bring similar cases, try to hone our arguments, make them better, look for different courts to bring them in. If something isn't working in the Ninth Circuit, we could try the Second Circuit, we could try the Fifth Circuit, and then get a conflict among the different circuits and take that up to the Supreme Court. So there are lots of ways at getting at this. But I want to, the little bit time left, I want to give both of you just an opportunity to give your final thoughts on the case and where we could be going in the future. Start with Joshua.
Sure. I think I'm gonna pick back up on that thought. The reason that I thought that Cedar Point was a great opportunity to go to the Supreme Court and the great opportunity to set important precedent was because it had a story that anybody that you could tell to your mom and anybody of any political persuasion could sympathize with it, that people were given the right to storm onto a private business's property in the wee hours of the morning, disrupt the business operations. That's something that can appeal to everybody. And that's an argument that we can use to push the envelope of property rights in front of any court. But where do we go from here? Cedar Point, I think, was a resounding victory. The arguments that we made were the arguments that were adopted by the court. I think there were there were opportunities, and even people close to me argued that we should have taken a more tactful approach that sort of tried to split the baby or to get a middle ground opinion. But I felt pretty strongly, and I think it bore out, that the issue here was clear and we could get a very clean opinion on the per se takings test. And I think we did do that. It cleaned up bad language in Loretto. It brought Kaiser Aetna and earlier takings cases into the per se framework that gives us a very clean and clear understanding of when the per se rule applies going forward. Now, there are exceptions that will certainly be litigated about. I think the ones that come to mind are the background principles exception. Now, one I talked about when the government takes the right to exclude from you, that it has to pay compensation, but there are certain things that I don't think include the right to exclude. For example, if you live on a piece of property that the government always had the right to access, let's say for whatever reasons that could be inherent in your title, that you don't have the right to exclude them. So the extent of that sort of exception to the right to exclude, I think, will be litigated. Property that's open to the public, I think that issue, or let me take a step back. The government can also take away your right to exclude when there are conditions placed on your property. To what extent they have to compensate, or when the conditions are in violation of the Nolan, Dolan, Kuntz test, I think will also form future litigation. And one thing, I think one other example that got thrown out at the Supreme Court when I was arguing was, what if the police are pulling somebody over and they happen to step onto your property? Is that and you don't have the right to exclude the police officer who stepped onto your property? And that's sort of they're right, you don't have the right to exclude that individual in that circumstance, but that's what I believe is the distinction between the taking of a property interest and a simple tort, a trespass that is not deserving of compensation. But that line of when repeated trespasses, when repeated torts become a taking of a property interest, I'm certain will become the subject of future litigation. But in any event, Cedar Point provides a very clear line on the per se takings test. I think that will be used by property rights advocates going forward. And it's certainly an opinion that we're very proud of here at PLF.
Thank you, Joshua. Paul, final thoughts.
So, as I was saying before, I think that we have a good opportunity to advance these takings law arguments that we've been making for, PLF's case 45 years, I think. This is a time when property rights are, I think, ready to be respected by this court. I'm actually hopeful that governments, people laugh at me when I say this, but I'm actually hopeful that governments start taking these cases into account and start adjusting their behavior. I had a case where the city attorney, the deputy city attorney, told the judge that owning property in San Francisco was a privilege and not a right. That attitude, I think, needs to change. And I think that if cities and states start respecting property rights a little bit more, they might put PLF out of business.
Thank you. We would love to go out of business. The founder of the Pacific Legal Foundation many years ago, when I first joined 38 years and a day ago, said, our goal is to basically win these cases and to go out of business and do something else. Unfortunately, government never stops coming up with good ideas to control us more, to take more of our property without paying for it, and to come up with creative arguments to do that. For every step forward, they try to make a couple steps backward. So I don't think our challenges with the government are ever going to go away. And that is why Pacific Legal Foundation probably is going to be around for a good while longer, because there are always going to be government challenges to property rights, new and novel ones that we haven't thought of yet, or revisions or revivals of old ones. Just as we get if we get rid of one aspect of rent control, they may come up with another. But it has been a privilege, not a right, a privilege of me to moderate this panel and to have everybody join us today. Sorry if we couldn't get to all of your questions. Do send us an email. You can look at our website, pacificlegal.org. If you find our find my email address or Joshua's to send a question, or we can forward one over to Paul if you'd like us to do that. Because we'd like to answer your questions and we'd like to continue to litigate these cases in the future. Remember, if you have a good property rights case and you think a Pacific Legal Foundation might be able to help and establish some new precedent, let us know. So with this, I would like to thank Joshua very much for participating today. Paul Utrecht from San Francisco, I'd like to thank you very much for participating this day. And I thank all of our panelists and all of our participants from listening today. Goodbye, everybody.